Hi, everyone, and welcome to today's webinar, Contracts 101 for Nonprofits and Small Businesses. My name is Jason Q. I'm a managing attorney for nonprofit and small business legal assistance programs at the DC Bar Pro Bono Center. For those who aren't familiar, the Pro Bono Center provides a range of legal services and resources for both nonprofits and small businesses. If you'd like to speak with an attorney for free to receive brief legal advice, or to access our library of training programs and webinars, or to apply for our nonprofit match program, you can learn about all these programs at our website. That is probono.center/NPSB. That's PROBONO.center/NPSB. But I am very pleased to introduce our speaker for today's event, Dean Dastvar, Managing Counsel at Verist PLLC. I'll let Dean tell you a little bit more about himself in a moment, but before I pass it off, just a couple of housekeeping notes. First of all, if you'd like a copy of the handout of the slides for today's event, for those listening live, that's available under the Handouts tab in your GoToWebinar platform. Just click the little white arrow to expand that tab, and you can see a copy of the PDF there that you can download. For those listening to an archived version of this webinar, a copy of the slides will also be available on the webpage that hosts this event. Also, we are happy to take questions from the audience during this live webinar. You will see a questions panel in your GoToWebinar client that will give you the option of asking questions during the presentation. I will be fielding the questions, and I'll sort of forward them along to Dean as they come in. We might also have some time at the end for questions. If we don't get to your questions over the course of the next hour, you can follow up with us afterwards, either through myself at the Pro Bono Center or through Dean, and we'll make sure to circle back with you for any remaining or outstanding questions. Okay, so with all that said, I will pass it along to our presenter, Dean. Hi, Dean.
Hi, thanks, Jason. Hi, everybody. This is Dean Dastvar. As Jason was kind enough to introduce me, I am a lawyer in the contracts area of law, and I specialize actually in commercial and government contracts. I teach that at Washington Lee University, and I also practice that in my daily practice. I've been doing it for about 14 years, and my hope is to give you a general understanding and sort of help guide you through the process of understanding and diagnosing a contract. Even if you don't understand what all the terms and conditions mean, at least you know what each of these key terms mean in general, and you know enough to triage your problem and quickly understand whether something might become an issue for you or not, or something's not a threat at all. If we have time, I would love to be able to talk about the basics of contract negotiation, but if we don't, it's perfectly fine. We can always save that for another day. Just a quick, here we go. So that's just a quick intro about me. My background, and I also happen to sit on as a board member of a national 501c3. So I have experience working for nonprofits. I've had experience working for small business. So the concerns that we see on a day-to-day basis are fairly common. I mean, there are certain things that are certainly specific to what you do, but as we go along, the key thing is to understand how to diagnose the problem and know when to call your attorney, or at least look at something a bit more carefully than you normally would, in order to avoid future problems. So a little more background on me. A quick background on my education. I went to University of Virginia for my undergraduate degree. The great thing was I studied cognitive science, which became an interesting addition to my ability to negotiate contracts, because you get into cognitive psychology, you get to see how humans interact under high pressure situations, and in the end, how to persuade them well. After that, I went to George Mason University for my MBA, and finally at American University, Washington College of Law. And I also serve on their board of advisors for government contract symposiums and curricula. I'm barred in Maryland, Virginia, and DC. I'm no longer corporate counsel. I'm a full Virginia bar member, and pardon that typo. And I also am licensed to serve in front of the U.S. Patent and Trademark Office. So the key thing to remember about contracts, rather than diving quickly into the nitty-gritty of the anatomy of a contract, which we'll do in a moment, it's important to remember one key factor. the key rule with all contracts is to remember that it is the memorialization of a relationship between people. You can't have a contract without people, and your contract is only as good as the people you trust, in addition to the kinds of terms and conditions you have in place. The best kind of contract is honestly the kind of contract that you never have to review. You write the contract once, and for 10 years, you never open it up again for any kind of review. Because what is a contract essentially? It is a set of rules of the road that every member of that contract, every party to that contract is subject to. Like any game, there have to be rules in order to progress in a orderly and systematized way. And commerce can't progress without those basic rules in place. And that's what enables us and our ability to enforce those contracts become key to how we operate. United States commercial system, runs on that basic premise, and a contract essentially becomes a unit of business that is done and sort of becomes a node in a larger web of agreements that come together to form a business. So digging a little bit deeper into that point, a contract involves people, and people involve relationships. And in the beginning of a contract, all you're doing is trying to define the relationship. They come in, there are several elements to a relationship. Trust, what level of trust do you have to the other side? Is this a perfect stranger that's coming in from out of the rain? You sign a contract every day without even knowing it. For example, when you order something off of Amazon, you are trusting that the 5 stars that are, and the 3,000 reviews of that, that provider, that vendor that you are working with is a form of trusted review that you can depend on. You're trusting that Amazon's reputation to deliver something to you is rock solid, and it's written in stone. When they say it's going to arrive by Wednesday, it's not going to arrive by Friday. It arrives at the day that is set by the parties. You also have to define the level of commitment. If you only need a certain kind of protection that only lasts 2 to 3 months, you're probably not going to be as complicated in what you're trying to write. Whereas if this is a far more sensitive piece of information that's being exchanged, or a kind of work that's being done, you're going to have to write something a bit more complicated. Contracts should also include measurable outcomes. In every relationship, there has to be a measured outcome. Why are we getting into this deal, and what do we hope to gain from it as we go through it, as we live through the life cycle of the contract? And finally, we want to, if those outcomes are not met, what are the consequences? When we're defining this relationship, what are the consequences if somebody wrongs the other party? If I don't get my delivery in time, if my house is not painted on time, if someone does a poor job of doing it, how do I remedy that situation? And finally, once you get past defining this relationship, you also have to define how it ends. Every relationship, fortunately or unfortunately, has an end date. It could be till death do you part. It could be till one of you screws up. It could be in any number of scenarios, but those scenarios have to be taken into account when you're developing that relationship.
Hi, Dean. We have an audience question, just going back to that framing idea of contracts really being about people and relationships. Someone's asking, do you mean literally like human people, individuals, or are we talking about corporations as sort of corporate people in this context? Where's the focus?
Sure. It's honestly, we're talking more in terms of commercial entities. So, but analogously, people. So, for example, imagine a company hires a single consultant. That's a relationship. If it's 2 consultants, one hiring the other to help complete a task, that's another one. It could be individuals, it could be a larger entity. In the end, though, it relies on the culture between the individuals, the level of trust and commitment between the individuals. No matter how big or small, that's going to define how well and smoothly this thing will go. Thank you for that excellent question. So digging a little bit deeper, now that we've looked at this from a more 50,000 foot view, let's dig a little deeper into the actual contract itself. What needs to be in there? Well, in essence, you have to define the obligations of each party. Who does what, where, and how. For the purposes of this talk, let's use a very simple analogy. A company has hired a painting company to paint an office space. Now, this was more of a commonplace thing before COVID, but I'm sure those days will come back and we'll be painting offices again, hopefully soon. But essentially, imagine that scenario. What's the obligation of the painter? What grade of paint needs to be used? How soon does the painting need to be done? What kind of staff should they use in order to paint the building? These kinds of questions become obligations. On the buyer side. So for the purposes of this talk and scenario, they have many different names, but for the purposes of this, we're gonna have a buyer and a seller, someone who buys services and someone who sells services. We're gonna focus on service-based contracts for the moment, but we can always expand the analogy to product-based contracts on a second talk that would go deeper into those issues. But just for the purposes of illustrating this concept, let's focus on services for this talk. So back to defining the obligations of each party. So on the buyer side, what does the buyer need to do? They need to pay. They need to be able to deliver the money on time. So for example, imagine it's a 2-year project to paint this whole building because it's a 50-foot skyscraper. So that's probably going to take a lot longer than painting a single-family home. So you're going to have to ask yourself, in order to keep the painting company afloat to hire all those painters, there has to be a cash flow in order to allow that to happen. So, okay, we've defined the obligations of the party. Now what? Now we allocate the risk between the parties. In every contract, it's like a tug of war. Each party is trying to gain more rights and fewer liabilities as they go along. You're trying to, but here's the key to every good contract. It has to be sustainable. You can't write a contract that's too one-sided because it just won't last. Unless, sometimes we do sign very one-sided contracts without even knowing it. For example, the click wrap that you see whenever you buy something from Apple. You're not really negotiating that contract. You're sort of accepting it as is. But in a lot of your agreements as a small business, as a larger business, you're going to see, or as a nonprofit, you're going to see that there has to be some kind of negotiation of the allocation of risk. For example, if someone gets injured while painting this office building, what's going to happen? Who's responsible for that? What level of risk did each party decide to absorb in that scenario? Next, now that we know who bears the risk, what are the consequences of that risk? Imagine I was the office building owner and I kept the windows closed and the fumes from the paint caused one of the painters to pass out. And this person had to be taken to the hospital. In that scenario, am I responsible for keeping the windows open, or was the painter responsible for opening the windows just to create airflow? So that's the kind of scenario that we see, that who bears what risk and what are the consequences. Imagine I was responsible for keeping the windows open, and the painter passes out. Then I have to figure out, what do I have to pay in terms of damages to the painting company for the hospital bills, etc., that would occur, if while they were painting my building. Finally, you have to allocate what work has to be performed by whom. In a lot of agreements, the buyer often is interested in how the work is done. If, for example, I want a fresco that's a detailed painting of a mural on a wall, I don't want someone who's just started to learn how to paint to do the work. That's that level of competence that I want in the microscopic parts of the job become another material part of the contract. When I say material, I mean a necessary part of the contract to make it work. When something is material to the contract, it means it's not just nominal. It's not something that you can just throw away. It's key to the purposes of the agreement. So to answer these questions, we have to identify the key objectives to every contract. We define the scope of the contract. How many floors are you painting? What color are you painting? What is the scope of your work? Imagine I have a 50-story building, but I only need you to paint 3 floors. That's the scope. Imagine I only need a certain kind of paint. That's the scope. Imagine it's a certain period of time. That's the scope. So that's you need to define that in every contract. I can't just write in a contract, paint my building, because that makes no sense when you're trying to argue over what that means. The key with every contract is you want to set as many rules early rather than later. Yes, it's a lot more work, front loading the contract and writing all those terms and conditions. They can get confusing and long and tedious, but this is what they do. They save you a lot of heartburn later. Imagine instead of saying, I want you to paint 3 floors this color, but in 3 months, I just say, paint my building. Now, the painter is going to have a different interpretation of what that is compared to me. So we're trying to eliminate those areas of ambiguity. Next, we set boundaries. What are you permitted to do on the job? What are you not permitted to do on the job? How late can I pay you? How early can I pay you? These are the questions that we answer when you're looking at boundaries. Measurement. Imagine I ask you to paint me 3 floors of a building and you only paint 2. Is that considered a complete job? No. So you set certain metes and bounds depending on how specified and complicated and sophisticated your service delivery is. You have to set your measurement accordingly. If it doesn't need to be that specific, you don't need to write it that much, and it becomes very difficult for the parties to have a sustainable agreement if it's overly specific. On the other hand, you have the consequences that come from, you have to set the consequences of not meeting those measurements. Suppose somebody only paints 2 out of 3 floors. Do I pay the person or the company for the 2 floors, or do I pay them 0 and hold out payment until they manage to complete it? At what point do I take them to court? Those are the sets of consequences that that need to be made clear. Now, here's the catch to that. If you don't make the consequences clear, in human psychology, people are more likely to skirt the rules. If you make the consequences clear in your contracts, like for example, if you only complete 2 out of the 3 floors I need you to complete, I will make you pay me $10,000 in liquidated damages, meaning you pay me a $10,000 penalty for not completing your work. So that's a consequence. So now the painter is on notice that if they don't complete the job, they're going to have to pay the consequences. And all this can be programmed into your contract. Finally, as I mentioned before, every contract has to have a sustainably shared risk. If you don't sustainably share risk, what happens? One side is constantly being bombarded with liabilities. They may go under, they may go bankrupt. Imagine I make the terms so difficult for the painter to operate. For example, I say, I'm not going to pay you a dime 2 years into the agreement, so you're going to have to hire 40 painters to paint this building, and you have to pay them out of your pocket until the final until the final ounce of paint has been laid down on the walls. That's going to create a lot of risk on the painter's behalf. Now imagine the painter runs out of money, has a nasty divorce, whatever happens, that company starts to go under, and they're owed my invoice, but I haven't paid it yet. So now I've made an unsustainable share of risk. So every contract needs to answer some basic questions. It doesn't matter if it's a consulting agreement, a licensing agreement, or any kind of general service agreement. You have to generally answer these questions. Where is this going? Meaning beginning and end date, final result, etc., what the consequences are. How much work share you're going to give me. For example, imagine I hire 5 different vendors to paint my office building. How much of it do I owe that person? How much of it do I owe that company? Company A will get 10%, company B will get 20%. Can I talk to other people? Often there is a confidentiality requirement in these agreements. If you can't discuss the kind of work you're doing, imagine this office building is about to go on sale, but I don't want the market to know yet. Then it would become important for me to include a clause that says, don't tell anyone that you're painting my building. They'll get the idea and start putting in their bids early. to buy my building. So in that case, secrecy becomes important. This segues into the next section, which is who else are we working with? Who are the other vendors? Who are the other buyers of service that are going to be part of this process? What kind of responsibility do they have? What information can I share? Imagine I can talk to other people. What can I say to them? What can't I say to them? Next we go to what promises can I rely on? If you tell me that you're going to pay me within 30 days, is that something I can rely on? If I ask for a specific kind of color or safety rating or organic level of paint for you to use on my walls, are you going to try to shortchange me, or is that a material part of the contract? And this is an obvious one. How much of the cost of the services am I going to carry? How much of this is the buyer's responsibility? How much of it is the seller's responsibility? Similar to the earlier scenario that I just mentioned, if the seller, has to carry the cost of all of its employees to paint my building, that's a lot of risk on their part. Well, the risk then, like the tug of war analogy we just mentioned, imagine the risk goes on the buyer. Imagine I pay the painter everything up front. Can everyone still hear me okay?
Yep.
Can everyone, sorry, it was just giving me a message for audio degradation, so I apologize. So back to the scenario. Imagine I'm the buyer and I say, I'm going to pay you $10 million to paint this office building up front. Now who bears all the risk? I do. The money is out of my pocket that I'm not investing, I'm not paying my employees with, I'm giving it to the painter. So the painter has complete power over me to get the job done late, early, and if the painter's late or does a poor job, now I have to sue the painter to get the 10 million back. So that again becomes part of that whole navigation of seeing, and negotiation of who bears how much risk and when. Finally,
Dean,
what parts of this? Sure, go ahead.
This is a little related, but we have an audience question. There's a lot of LLCs on the line, and this audience member is asking in the context of commercial leases, but it's probably relevant in other contexts. They're asking, should the lessee always sign a lease as the LLC or other corporate entity rather than as an individual? Does that, give additional protection to the business owner? Do you have any general practice on what entity actually signs the contract?
Absolutely have your LLC sign the lease, because what you're doing is you're creating veils of protection and walls of protection that need to exist. So they can't come after your personal. Imagine you, the business owner, sign it as a person, as a human entity rather than as a business entity. The issue with that is that now all your personal assets. Imagine you have 3 different companies and you're getting revenue from all 3, and you're sued by the lessor for the lease of your property. They can then go after your other sources of revenue once they run out of one source of revenue. However, if the LLC signs it, only the LLC is liable. I hope that answers your question.
Great, thanks.
No problem. So that concludes this general, the questions that are asked about the general quality of the contract. Now, there are many types of contracts. As was a very good question that came up was the leasing question. Leasing is a form of a contract. Consulting agreements are contracts. Licensing agreements, if you have intellectual property that you're giving out, a certain know-how, a certain trade secret that you're using, a certain copyright that you're using, you can use licensing agreements for those. Consulting generally deals with service. Confidentiality deals with, for example, initial discussions that companies are having with each other, individuals are having with each other to even do business together. They often sign an agreement known as an NDA to protect what's being said. So they all share certain elements. NDAs are a little bit more watered down in some ways, but essentially they all share certain elements that you have to keep take into account while you're doing work. So how do you address them in a contract? Key sections in a service contract include, you have a changes clause, you have a confidentiality clause, you have a limitation of liability clause, you have an indemnification clause, you have a payment clause, a termination clause, and inspection and acceptance. Now, there are many more clauses than this, but these are the ones that we're going to tackle today because they're key in many ways, because they address that tug of war that we've discussed and what the obligations of each party are. Now, every agreement is going to be complex in its own way. It's going to be heavier on certain other issues. For example, licensing agreements deal more with intellectual property. Leasing agreements may have more complex clauses regarding termination, but they all sort of share this similar DNA. And of course, we're using the painting example for the whole thing because it's a nice, simple example that will help demonstrate the point throughout this talk. So I would argue one of the most important clauses in all contracts is the limitation of liability clause. What a limitation of liabilities clause is for is to armor yourself and your company. The questions it seeks to answer are the following. What is the limit of one party's liability in a deal? Why it should be limited? Why it shouldn't be limited? And should the limitations be asymmetrical? And of course, to what extent it should be limited. And you also include a term that explains what is not included in terms of limitations of liability. So for an example, going back to the painting example, I ask you to paint my mansion, that's an office, for $10 million. It's a sprawling compound, we need multiple painters. It's going to take about a year to paint. And the parties want to agree to limit damages. One party can propose, there's two ways you can propose to limit damages. There's a relative way, which is tied to the price of the contract, and there is a fixed way or an arbitrary way that you can do that. I'll demonstrate. Imagine the contract is worth $10 million, and I want to limit my damages to 1 time or 2 times the value of the contract. So the total value of the contract being 10 million, the total amount that I could be sued for becomes 20 million. Now, say for example, the value of the contract increases or decreases. Imagine I expand the contract to mean 3 or 4 different buildings in addition to the original one. Now, it proportionally increases to the size of the risk. Well, it's meant to track the size of the contract as closely as possible. It's never perfect, and it's always going to be arbitrary in a way, but it's better to define what the damages would be rather than to leave it undefined, because then you're essentially exposing yourself to unlimited damages, which is far more dangerous. Do include this clause in nearly every contract you sign. It is incredibly important because you need to make sure, whether you're the buyer or the seller, how much you can be ultimately liable for. And why that's important is that as you grow as a business, as you grow as a nonprofit, you're going to have a portfolio of contracts. That portfolio of contracts come with risks. Imagine you're a small business and suddenly you have hundreds of contracts. It's going to start adding up if you haven't limited your damages. So when a company is looking to purchase you, or you're looking to purchase a company, they're going to look at that portfolio of contracts and say, wow, you're exposed to so much risk if even one of these screws up. So for that purpose, it's important to include that. The second way you can limit damages is by the arbitrary means, where you set a fixed value. You can also make it a hybrid version, which I'll get into in a moment. Say I say that I'm the painter and you're the owner of this building. And I say, I will do all the work for you. However, you cannot sue me above $1 million. So if, for example, I cause $10 million of damages, that's $9 million of damage. Imagine I do some negligent activity and I flood your building, and it creates mold, and there's $10 million of damages. You can only sue me under this hypothetical scenario. You can really only sue me for $1 million. That's not including, or depending on how you argue or negotiate for it, that may not include attorney's fees. So let's just say $1 million. The hybrid way you can do it is you say the lesser or the greater of, and you have a fixed amount and a relative amount. So the lesser of 1 million, or 1 times the value of the contract. say again, it's a $10 million contract, and 1 times the value of the contract would be $10 million. However, I included the caveat that it's the lesser of 10 million or 1 million. So again, my liability is only 1 million. Often limitation of liability, limitation of damages doesn't include certain areas, and this is usually industry standard in most service-based industries. And that includes death, personal injury, a breach of confidentiality, breach of intellectual property, because usually it affects more than one party. There's always a third party that's being injured. If somebody dies on the job, there's usually a family that's aggrieved. If there is intellectual property violated, there's a company who created the license, or like, for example, imagine I bootleg copies of Microsoft Office. Microsoft Office at that point has been aggrieved. If everybody has, the problem is that there will be multiple suers, multiple plaintiffs in this situation. Because of that, and because the kinds of damages that are received cannot easily be quantified, often the limitation of damages does not apply to that area. Now, that's usually addressed in another section, which we're about to get to, called indemnification. Now, I like to call the indemnification the bodyguard clause. It's essentially stepping in front of the bullet. It is there for when there is a severe wrong that is accounted for in the contract. Say, for example, what's known as gross negligence, which is something absolutely horrible that you did. Wrongful death, property damage, breach of privacy, breach of intellectual property. Imagine someone's health records are posted online by some hacker. In that moment, this bodyguard clause kicks into effect. An indemnification clause's job is to step in front of that bullet for the wronged party. So imagine I'm the buyer and you're the seller. You're painting my house, and while painting my house, your truck runs over the neighbor's dog. And the owner of the dog sues me. In that moment, because you caused damage, and it's a grievous form of damage, and this person was driving horribly negligently, basically with gross negligence, or willfully was driving like there was the video game Grand Theft Auto and was running over things left and right. Your truck driver was driving your truck to do a job for me, and the neighborhood was aggrieved by this. Your job is to then step in front of the bullet that was meant for me, because I'm the sued party, because I own the house, my property's on the lot, etc. Because I'm the sued entity. You're pushing your LLC, your nonprofit, your personal self, if you're just a single consultant, in front of me to take that bullet for me. Now, there is a catch to this. When you're using an indemnification clause, again, this goes back to sustainable shared risk. The entity that's taking that bullet for you has to be able to sustain that damage, because sometimes it's just not enough. Imagine it's $10 million worth of damage and your company is only worth 1 million. Then you're sort of left in a difficult position. Another important clause that you'll see in a lot of these agreements, especially if it's a service-based agreement or a product-based agreement that involves the delivery of some good or service, is inspection and acceptance. You're setting rules for what is acceptable. If I order a bicycle and it's missing a wheel, is that acceptable? No. I ordered a bicycle, and as the name implies, there are 2 wheels. You sent me a bicycle with 1 wheel. This thing is rendered unusable. So for me, that on a very elemental way, that's considered unacceptable. So, but it gets more complicated the more complicated your service is. Imagine you're developing a software. When is that acceptable? Imagine you are painting a fresco and it's a very subjective judgment. When is that acceptable? You're right, and not only that, on the seller side, they're concerned about inspection. Imagine the buyer reserves the right to inspect you constantly. Day in, day out, they're on your job site staring at you as you're doing it. That's obviously going to interrupt your work. Imagine they keep taking your laptop from you and reading what you wrote in your emails. Imagine they give themselves the right to audit you at any given moment. That then becomes an issue for the seller. It's going to cause delays in delivery. And if you don't take that into account, you're technically in breach even though you did nothing wrong. Imagine, I'm painting a house and the buyer interrupts me all the time, to pull out my staff and talk to each of us individually and let us go back to work after an hour. It chips away at my schedule, and eventually I'm late by 5 days. And then the buyer says to me that I haven't painted the house on time. Is that fair to me? No, but it's written into the contract. Remember that when you're writing a contract, you're essentially creating a law unto itself. State, federal, and municipal rules and case law tend to favor the drafters of the contract when they've had a chance to fairly negotiate it. And judges don't like to substitute their opinion for what is written into the contract. They don't like to do that. What you wrote into your contract is your doing. If it's unfairly and you've had a chance to negotiate it, that's your problem. The judge or the state is not going to take responsibility for that. So it becomes incredibly incumbent on you to make that decision clearly and to do it effectively. There are ways you can write this clause. For example, buyer may inspect services, deliverables, and/or supplies delivered by seller for reasonable defects. You can include the term reasonable in your contracts to sort of give yourself some wiggle room. And imagine you don't have an exact definition of what reasonable is. That's okay. The term reasonable in contracts, if you're negotiating them yourself, is a useful term as a wiggle room. So when you're writing something too narrowly or too broadly, it tends to backfire. Payment issues. You want to define in your agreement, when do you pay and how do you pay? And also what happens if the buyer doesn't pay or the seller doesn't deliver. I'll give an example. Your invoice is due to me at the 5th of the month. That's how you define when to pay. How do you pay? Okay, well, you have to send it to my international bank account in Switzerland. That's a means of paying. And when, it has to be arrived by electronic funds transfer in 60 days. That's the how. Now you have to take into account the what ifs. What if the buyer doesn't pay? Okay, well, suppose you're the seller. Do you have the right to walk off of the job? Imagine I'm a painter. Have I written into the contract the right for me to stop work if you haven't given me payments in the schedule that you promised me that you would? What if you're the painter and you don't do the job right? Can the buyer say, you know what? Imagine I divided it into 5 payments, and by payment 3, it becomes clear to me that you're not going to do the job right. Can I stop paying you? Now, the default rule is you can't simply stop doing your obligations on the contract because the other party stopped. You have to keep going as though nothing went wrong, unless you expressly call that out in your contract.
And Dean, we have an audience question that's related here. So someone from the audience is a one-woman LLC. She's saying that her clients are often organizations that get money from USAID. So while the contract says that they're obligated to pay within 30 days, the payments are often late. What remedies does she have? So you talked about sort of stopping payment, but this seems to be something that's invoiced after the fact. So what kind of remedies exist in that situation? Maybe that we could put into the contract, or even if they aren't in the contract.
Certainly. So a great remedy before you get into the situation is to include what is known as an interest clause. So imagine you say that if you're 30 days late to pay me, you will owe me 5% of the invoiced amount every month you're late. Now suddenly that starts to add up, and what's going to happen is that adding up of cost is going to be a painful consequence. As we go back to the earlier slides, consequences are important and they have psychological effects. Now, if they haven't paid you yet, you still have to perform your contract. Usually under a government contract, you'll see that you can't just stop work. And unfortunately, that forces you to get financing for paying your employees, etc. But what happens is that in your subcontract with a prime contractor, you can include clauses that say you can stop work if they're late by 60 days. But if your contract doesn't allow you to walk away, you can't. So it's very important to negotiate that in advance. I hope that answers your question. Termination. So how do we get out of a situation? Every contract has to have an escape. Every contract has to have an end. When we're looking at termination for convenience, termination for cause, and termination for insolvency, those are three basic ways you can get out of a contract. Now, the most friendly way to get out of a contract is the way it sounds, a termination for convenience. You're saying that's essentially a term of art that says you can get out for whatever reason you want so long as you give me enough notice. Say, for example, you've hired me to be your painter, and I've been painting, I've been doing a decent job, but you just don't like me. You don't get along with me, I'm rude to you, but I still do the job fine. And you're like, you know what, my cousin can do the same job. I just want to hire him or her to do the job for me, and I want you to leave. Now, you should include a termination for convenience clause to allow you to do that. Because once you've signed the agreement and that this clause doesn't exist, you're stuck. Because if you don't pay and just say, get off the job, you have to have a written termination agreement or something if it's not already pre-programmed into your contract. So you want to include that escape clause for both sides. Sometimes you want it to be one-sided depending on the deal. For example, if you're in federal contracts and you're a prime contractor and you depend on your vendor to keep you afloat while you're doing the work, you can't afford them to walk off the job even if they give you 30, 60, 90 days notice. So, you want to eliminate that and negotiate that out. So sometimes it's useful, sometimes it's detrimental. The termination for cause or default. Well, this is the most basic one. Essentially, if something is not according to the material specs that you've written into your contract. Imagine I asked you to paint my walls white, you paint the blue, that's a material difference. If I've said that this is a material part, that this wall has to be white and of a certain grade of paint, and you didn't do that, that's a termination for default. Now, termination for convenience and default tend to be different in how you pay the other party. If someone is terminated for cause, you can sometimes cut off payment for the poorly completed tasks. In termination for convenience, it's often negotiated that, okay, whatever work you've completed up to this point, and maybe some off-ramping costs, like, some costs for you to find another job or, pay out your employees or de-escalate the work you're doing, I'll pay you an added fee to make you go away, basically. Finally, termination for insolvency. This doesn't happen as often, because it requires bankruptcy. Imagine your subcontractor can't pay his employees anymore, or your vendor can't pay their employees anymore, your seller can't pay can't buy paint anymore, and they just can't do the job anymore. You can end the agreement based on that. Imagine the person who's asking you to paint the building, or the company that's asking you to paint the building, is no longer capable of paying you. You can walk off that job for bankruptcy. So now, why is termination so important? It's important to negotiate this clause to provide yourself a way out even under tough circumstances. You don't want to be forced to perform or face dire penalties. You got to give yourself an escape hatch. So imagine you're painting the house and there is a family of bears that moves in, one night while you're home. You come back the next morning and sure enough, there's a family of bears living in the office. What's your escape there? Imagine, however, the kind of work is in a certain, you're painting an office building that is known for bear attacks, and you've written into your contract that having bears come onto the property is considered part of the hazards of the job, similar to cutting sequoia trees, or you got to be ready to receive some kind of damage from falling from high heights. Certain things are built into the kind of work you're doing. But if you're in the middle of the suburbs and a bear somehow moves into a single family home that you're painting, should you be forced to perform? Well, the answer is no. But unless you write that into your contract, that doesn't become a part and parcel of the whole thing. It doesn't become a key requirement of the contract. Confidentiality. Often in your agreements, especially if you're in technology, healthcare, many industries that are knowledge-based, confidentiality becomes a key aspect of what you're doing. What is meant to be kept secret? How is confidential information defined? Well, simple. You have to write that into your contract. It can be whatever you want it to be. Sometimes they're written very broadly, sometimes they're written very narrowly. The problem with writing it too broadly is that now you have many, many other obligations to, and it's hard to define what is and isn't, considered, just water cooler talk and what's considered protected. So you want to keep this language as focused as possible, especially if it deals with sensitive information. If you're telling me the last night's score in football, that shouldn't be considered confidential. You have to also define how long you want to keep something confidential. If for example, you're trying to close a very important deal and you don't want the market to know about it, it should be for a reasonable period of time that covers that period and a little bit further. What if something was already out in the public eye? Well, you have to take that into account too. You can't hold someone's feet to the fire. If something was already public, you can't sue them for it. Nor should you be sued if something becomes publicized later. Intellectual property. In this clause, you're essentially saying intellectual property can be a number of things. It could be patents, trademarks, copyrights that are important to you that you're bringing to the deal. Imagine I, the painter, have developed a patented way to apply paint that will last 10 years longer than it. Do you own the patent because I painted your walls with it? No, you shouldn't, but I'm sort of giving you a license to have it on your walls. How do I remove that rule if, how do I remove that if it becomes an issue? Do I come into your house and chip off the paint if you then sell the house? Is that fair? Well, you have to define that in your agreement. You also have to define the damages, because IP infringement becomes this runaway cost. And it's hard to define, what losing a patent. It's like saying, for example, imagine I was an executive at Coca-Cola and I revealed the trade secret of how to make Coca-Cola soda to all of the competitors, including Pepsi, and they started mimicking it. What are the damages that Coca-Cola is owed by me? The changes clause. Now, every contract has to be able to change with time, especially if it's a long-term agreement. Not every relationship stays exactly the same. Situations change, the owners of the company change, all sorts of factors in an ever dynamic world change. A contract is meant to be an anchor point, but it can't always be completely fixed. So you have to have some kind of leeway so the parties can get together and figure out how you change it. Sometimes you create a clause that's for unilateral changes, where you reserve all the power to change the agreement as you wish without any kind of input from the other party. Sometimes it's bilateral, where both parties get to decide, to lengthen the contract, to increase the scope of the contract. Say, for example, you and I are back to the painting scenario. I ask you to paint 3 more houses for the same price. Well, per square foot, let's say. Well, that's not written into the agreement, so you can't just start doing it. And imagine we get into an argument while you're paying the first or second house. How is a judge supposed to figure out, what that's supposed to be worth? We need to have the ability to modify our agreement, and that's what the changes clause lets us do. Who needs to sign it? Does it have to be in writing? Those kinds of questions are answered there. It should include certain things that say, it's done by mutual written agreement. And how do you do it? Well, you write it into as an amendment to the contract. So you're basically writing a mini contract that attaches to the original contract. You both sides sign it, but both sides will sign that amendment, and that becomes a part of that living document. When can you start implementing it? Again, you can write that into your amendment, saying effective today, November 11 or November 12th, 2020, these changes will not go into effect. I will paint 3 more houses for this rate. And what do you do when the law changes and it's outside of your control? Well, you take that into account in the amendment if your attorneys catch it in time. Non-solicitation. Now, this is usually written in such a format that you can't directly or indirectly solicit each other's employees. This happens a lot under services agreements. Suppose I have a artisanal painter that can paint murals. And you ask me that in addition to me painting this house, you want me to include this artisanal painting and this 30-foot mural in the wall. Now, imagine I'm part of a larger contract that you're doing for a third party, and you think this person's so talented that you want to steal them. Well, this clause will prevent you from stealing my employee for a length of time. Non-competition. Suppose you and I are in the same business. I'm in the painting business and I hire you to do part of a job for me. Now you start talking with the end customer that I have. I'm buying your services, but someone's buying my services. How do I keep you from running around and talking to these people that are part of my portfolio when I've given you access to them because you're doing the work and you're available to talk to these people? Well, the way you do that is that you have to write it in a way that, to make it legally enforceable, remember these three things. You have to have geography, scope, and time to make a non-compete enforceable. Suppose I am a gym trainer, a personal trainer at a gym, and you tell me you can never train anyone in physical fitness in the United States for the rest of your life. Well, that's completely unenforceable and it doesn't really work. It's totally unreasonable and it would ruin my livelihood. But suppose you say in Fairfax County, Virginia, you can't do it, you can't, within a 20-mile radius of this gym, you can't do this kind of physical training. Suppose it's specifically for running athletes for the next 3 years. Now that hits all three of those categories. There are ways the vendor can push back by lengthening or shortening the scope, tightening the scope, shortening the time, tightening the geography to be able to push back on these restrictions. A contract is very similar to a computer program. They have levers that you can, like light switches, you can turn them on and off. They also have dimmers. You can make it brighter or darker. One of my favorite clauses is the disputes clause. Differences will inevitably arise in every agreement. The question is, what do you do when they happen? Do you go to open court, or do you create a venue for the parties to discuss their grievances and find a way to a resolution quickly and efficiently? Without one, your contract is essentially unsustainable. So what are three ways you can do it? Well, there's mediation, there's negotiation, which we won't include here, but like just basically between the two parties just talking it out. There's mediation, which is basically a non-binding third party comes in and helps you, almost like a therapist, and helps you, give you business therapy and let you guys talk out your issues. There's arbitration, which is basically a private judge, which you hire and you pay for, but is usually specialized in your field and lets you figure out what your issues are on a more focused basis. And you also have litigation or open court, where you go to your jurisdictions that you've listed in your contract, or wherever your site is in if you haven't listed it, say New Jersey, Delaware, DC, wherever you've listed it, and you go to court in the traditional way. You hire lawyers and the prevailing party wins. The prevailing party can make the losing party pay for the legal fees. Well, there are problems with that. Well, mediation is great if you want to keep it very amicable, but often it's not very efficient because sometimes you just need a resolution. Mediation is great when there's a way back in terms of your relationship. There was a little bit of a stumble, but nothing that's totally out of whack and not fixable. It's not great for all scenarios, and sometimes it's a waste of time if things have gotten very adversarial between the parties. That's when arbitration comes in, and this is my favorite, because while there's some upfront costs, it's streamlined, because if you're in a specific area or industry, it creates subject matter expertise. You can pick an expert to be your judge. Imagine you're a painter, you want someone who's painted 100 houses, 1,000 houses, and has had a huge company and has sold it to be your arbitrator. So they're like, I know how this industry works and how parties interact. Not only that, imagine you want to keep this disagreement offline. An arbitration is usually confidential. What transpires between them, the parties, is not publicized. There's also what's known as limited discovery rights. You don't have endless reams of paper and evidence being brought in to litigate this issue. You're given a tight window of time and a tight window of evidence you can bring in to talk about, like what emails you can use, etc. Finally, it's binding. Once you get an arbitral decision, you can take it to any court and it's enforceable. Open court, it's old school, it can take a lot longer. It is binding, but it's also public. And a lot of folks don't want their name in the news. Now, I'm not saying it's never good, it's just sometimes not good. So I'm going to leave you with some practice tips that are key as you're building your portfolio of agreements. And often a sign of success is that your number of contracts are increasing. As they're increasing, you need to have a way of organizing them and keeping them steady and within certain guardrails. Tip number one is definitely write a contract playbook. So make sure the areas that I've similar to the ones I've discussed, but that are part of your template agreement, whatever it may be, whether it's a consulting agreement, a leasing agreement. So you have outlined those key terms and you've defined, and you already know what you're willing to accept before you enter live negotiations. It's like knowing what car you want to buy and for what price before you enter the car lot. You want to know what features you want, what features you don't want, and what you're willing to accept. You don't want to get into a negotiation without a plan. And what a playbook does is that it sets up a standard plan so that even if the owner of the company is not there, their lieutenant, their second in command, whoever is in charge, the account manager, whoever's there, knows what they can and cannot negotiate for, even if the attorney's not present on that negotiation. That happens a lot on high volume negotiations. Second is to bring in all the concerned parties on your side to build the playbook. Now, I've included a sample of what my law firm uses in terms of, for one of our clients, what we've used as a standard. Obviously, we've gotten permission to show you this. For example, we define a position, what you're willing to accept, what you're not willing to accept, and your fallback position, which says, okay, suppose the other party doesn't agree to 1 time the value of the contract. We can agree up to 2 times the value of the contract. Suppose that even the fallback is violated, you go to the third column and you say, okay, who in our organization, if you're a one-person LLC, you don't have a problem. You just make that decision and make the approval on the fly. But if you're growing as an organization, you're going to want to have people who have levels of approval that would be for a specific clause. Like, okay, we can approve higher than 2 times the value of the contract if the CEO says yes. So that, in essence, becomes the key of looking at every contract. Every contract has a life cycle, methods of risk mitigation, and methods of negotiation, and ways of triaging them that you can do that will protect your company in the long run and in the short term. So I'd like to thank you all for your time. I'm happy to answer any questions you have, whether online or offline. You're welcome to email me or email the DC Pro Bono Bar team. That I would be more than happy to field your questions at any time. It's a very complex world out there. It's tough to negotiate. It's tough to navigate at times, but the more you do it, the more savvy you're going to be. And having this in your arsenal is going to be helpful in terms of advancing your contracts and hopefully, running a successful enterprise. Thank you.
Awesome. Thank you, Dean. Do you have a few minutes to stick by to do some audience questions? I know we're kind of going to hit the hour. Maybe some people will have to drop off, but we can knock off a few if that's okay with you.
Absolutely.
Awesome. Okay, so one audience member is asking, for smaller jobs, is kind of a simpler, more bare bones contract okay? And if so, what are the most important elements to still keep in?
I would say, make sure that you have the basic elements of the agreement, essentially saying like, what level of risk you're willing to accept, like limitation of liability, and cap your damages as much as possible. So your most important thing is to cap your damages. Even if it's a small contract, imagine you're doing something very small like painting one room, but you accidentally injure, the resident of the house's kid. You don't want to be, imagine you hire a consultant to do that work for you and they do that. You don't want to be responsible for, something that wasn't your fault and didn't happen. So even though the monetary value of the contract was low, you still want some essential terms. So if you, in the absence of anything else, definitely have a cap on damages.
Great, thanks. This is an interesting question. Someone's asking, how does a nonprofit contract differ from a commercial contract? And that's an interesting distinction to make because, in my experience, a lot of the contracts that nonprofits sign are nevertheless still commercial contracts. Nonprofits are businesses just like for-profits. But can you think of categories of contracts or situations that you can maybe classify as a nonprofit contract?
Well, often you said it very well, Jason. Often whether you're nonprofit or not, your agreement is governed by the same rules of commercial agreements as anyone else's. It's rare to see where a nonprofit status will absolve you of certain things. Certain things, of course, exist. Like, for example, winning a grant as a nonprofit gives you special rights, and you are given certain privileges that a for-profit organization isn't. The tax waiver that you receive, or the fact that you're not being taxed by the IRS and follow certain compliance rules, become part of the contract. But also, as I mentioned, the compliance rules become higher for a nonprofit, that you may want to have your for-profit vendor agree to. So, if, say, for example, they're doing your accounting, or they're doing work for you, and there's a certain accounting requirement you have as a nonprofit that you have to report to the IRS, you have to flow that requirement down to your vendor, or vice versa, flow that requirement up to your buyer. That would, essentially make sure that you are in compliance with those rules. That's the biggest fear I have, is you falling out of compliance with your nonprofit requirements.
Yeah. One other thing I'll say on that question is, nonprofits might deal with relatively more government contracts or government grants. And so when you're getting that government money, all the fundamentals are still there, but as you said, there could be an added layer of complexity in terms of grant compliance that's really going to be coming from the grantor. So when we talk about what the deliverables are, what the rules are, it just might be more complicated. All these fundamental aspects are still going to be there, but there's just going to be more to understand and more issues to look out for.
Absolutely. I ran into that when I was, applying for grants as a professor. So, I mean,
Yeah.
through my, so, I mean, yeah, there's layers and layers of rules that get added on.
Yep. So you talked about confidentiality clauses. Someone has a specific example. So if I hire teachers for my school and I train them to teach languages using a specific methodology and specific books, how can I prevent them from using those methodologies and books outside of my school and our employment relationship? Is that something that we can use a confidentiality clause to protect?
Well, it would be a mix of confidentiality and intellectual property clauses. So, one, you would mark your materials, as confidential and proprietary, or just proprietary, so that essentially you're putting them on notice that this is intellectual property belonging to my school. Second, what you would do is you can certainly say, okay, you can only disclose it for a limited scope, like only to teach under this contract, to teach 10 students. I'll let you use this. Third, you write into your confidentiality agreement, like, or your intellectual property agreement, clause. I've seen it done both ways. Who you can redistribute it to. You can also include a licensing requirement saying, okay, you can only use you're licensed, in a revocable way, meaning I can pull back this license from you whenever I want, for this purpose only. And if you violate it, there are consequences. And you can even include some kind of penalty if they do, like liquidated damages. That's just a fancy way of saying a hard penalty that you write out in numerical form. Like, if you sell my book or use my book to train somebody outside of my purview, outside of my governance, outside of my right that I give you, I can sue you for $10,000 per violation. You can do something like that to sort of dissuade your teachers from stepping outside of their boundaries.
Excellent, thanks. A couple more quick hits. This is a great question. Is there any way to respond to a client who refuses to remove clauses from a contract that don't apply to your situation, and they say, oh, that's just our standard contract, or that's just our boilerplate language? Is that a problem, and how would you negotiate that?
Well, I've heard that a lot, and it depends on how innocuous or problematic the clause is. Imagine it's something that could become a problem later. They're like, oh, no, it's just some standard. I've heard this countless times, and I know it can be frustrating. I've heard this a bunch of times. What you want to do is, well, it's not, you can try to fight it out if you know that it's going to become a risk later. And often reason prevails. You're like, look, this will become a problem if, this unrelated portion of this contract, this thing that I'm doing for you, kicks in, and I get sued over this. I don't have any recourse. I don't have any remedy for this. You're going to screw me over if I let this happen. So please remove it. It's not relevant. If they really are, you got to evaluate how innocuous or how, how dangerous that clause is for you in the long term. If it's not dangerous, I would leave it alone because it will never kick in anyway. But again, it's on a case-by-case basis. If they're really digging their heels for something nonsensical, because remember, not everyone on the other side of the table, and this is more on the contract negotiation psychology part of this discipline. You got to understand that most times you're going to run into some irrationality on the other side, and you have to accept that. That's just part and parcel of the chaos that happens here. But managing that chaos becomes, either your attorney's job or your job. And if you see that becoming a bigger risk than it should be, dig your heels in. But if you see that it's innocuous and it's not dangerous, let it lie.
Got it. Thanks.
Sorry for the long-winded answer.
No, that's awesome. This is an interesting question. If my clients don't sign a contract and some relationship develops, is the business still liable for damages? And sort of, we're talking about contracts this whole time. What if there just is no written contract? Kind of what's the situation then?
Whether you like it or not, if there's in very, very fundamental contract laws and rules, in every Commonwealth system, UK, Australia here, once you do something and you do something in exchange for that something, there's a contract, whether it's written or not. That's why you must write a contract, because say for example, when you go and you sit in a barber's chair and you want your hair cut, or you sit in a salon chair and you just start working, that's a contract. Whether you haven't written a single piece of paper, you haven't done anything, but it's assumed, you see a price on the wall that says, say $20 for a haircut, you sit down, they cut your hair and you don't pay, you're still liable. So same idea, it doesn't matter if it's $20 or $20,000. That's why you must write something down. I cannot emphasize that enough. Write the rules down early. It is tedious, but it will save you heartburn later. It is like a seatbelt in a car. You got to have it.
Awesome, thanks. And then let's do one last question. This is sort of going back to an earlier theme of sort of corporate entities and who's responsible for what. So someone from the audience is saying, I have a sole proprietorship and I signed a contract with a client who's now disgruntled and I'm afraid that they'll try to sue me. Today, I became an LLC. Am I protected by that LLC status, or is it too late given that I didn't sign the contract originally as this LLC?
Well, that's a tough spot because you did sign it as a sole proprietor, so you're personally liable for that. However, if you can calm this person down, so here's again negotiation psychology. If you can calm this person down long enough to do what is called a novation or an assignment of the contract to your LLC and say, listen, I need to, I'm just going through some restructuring. I'm going to continue work for you. Just go ahead and sign this agreement, which supersedes my previous agreement with you, and terminate the previous one. That is a sort of a sly way of getting it to shift over to the LLC. But until you can do that, unfortunately, you're the one on the hook because it's your name on the dotted line, and it's it's a sole proprietorship that you did. Often, and I've seen plenty of my clients do this. Sole proprietor, you win the business before you start the LLC because you didn't know you had a business until your first client signed the contract. So I completely sympathize. I understand. You wanted to win the business, you got the contract, but try to find a way to sort of de-escalate the situation. What you can often do is give them something in exchange for them to allow you to terminate the previous agreement and have a new agreement superseded. Say, for example, you'll write off a portion of their invoice. You'll do something. You'll give them something in exchange for them to, re-gear this structure of this agreement. And then they often tend to soften up. Often, when you give something without asking, the other side has a human need. There's a human psychological need for reciprocity. So tactically, that's what I would advise.
Awesome. Thanks so much, Dean. We couldn't get to every single question that came in, but you have Dean's email there if it's a contract-specific issue. I've also put my email in the chat. It's jqu@dcbar.org. If you'd like to follow up with us at the Pro Bono Center about a contract-related question, or if it's more generally related to corporate entity status, and I saw some questions around liability and insurance. For questions like that, feel free to also turn those around to me and our team here at the Pro Bono Center. I'd like to give Dean one more thank you and express our gratefulness that he's been able to present today and be our contract guru for the afternoon. So thanks, Dean.
It was an honor and a pleasure. Thank you all so much.
Awesome. Great. Everyone enjoy the rest of your afternoon. Thank you for joining us today.